All right, let's go over how to review the criminal statutes for the state of Missouri. So when you go to the Missouri Revisor of Statutes, and you literally can just type in a Google search Missouri statutes, you're going to notice that the criminal ones are going to fall mostly down in the 600 area here. Crimes and punishment, 556 to 600, kind of in that area. When you click on that, you've got all kinds of different categories, and these are things that we've already talked about in this class, such as, offenses against a person, sexual offenses, prostitution, arson, burglary, trespass, all of these different things, robbery, stealing. So all those things are in here. We're going to look at a couple of these just to kind of break it down, how you analyze them, because statutes are written in some kind of crazy language. And I'm going to expect you to be able to interpret those statutes. So here's one, for example, which is talking about intoxicated or drugged condition. We've already talked about this in class, but let's look at the statute. A person who is in an intoxicated or drugged condition, whether from alcohol, drugs, or other substances, is criminally responsible for conduct unless such condition is involuntarily produced and deprived him or her of the capacity to know or appreciate the nature, quality, or wrongfulness of his or her conduct. So this is saying if someone committed a crime and they were involuntarily intoxicated or otherwise at lack capacity, involuntarily. So if you went to a party and got drunk, you're not involuntarily intoxicated. Okay, then it says the defendant shall have the burden of injecting the issue of intoxicated or drugged condition. So that means, like, when they take you to court and the prosecution is going to say they did this thing, you, the defendant who was involuntarily intoxicated, has to prove that. So you have the burden of bringing that up and proving that that issue existed. And then finally, evidence that a person was in a voluntarily intoxicated or drugged condition may be admissible when otherwise relevant on issues of conduct, but in no event shall it be admissible for the purposes of negating a mental state. So they're saying you might be able to say when you were voluntarily intoxicated or drugged, like you took drugs on purpose, that might be something that you can use about certain conduct, but you cannot use it to say you didn't have the capacity. And in a trial by jury, the jury would be instructed that if you were voluntarily intoxicated or drugged, they have to take that into evidence, and that, would prove that you did have some responsibility. Okay, let's look at another one, robbery. Robbery in the first degree. One other thing to watch in statutes is or. Sometimes people look at these and they think all of them have to apply. That's not the case. It's just or. So this one here is the first degree robbery. A person commits the offense of robbery in the first degree if he or she forcibly steals property. And, for first degree, in the course thereof, he or she or another participant in the offense. So notice that says or another participant in the offense. So you and your friend go in, and your friend is doing the forcible stealing, and you're just with them. You are a participant. So you have also committed robbery in the first degree, according to these statutes, right? Okay, so first off, forcibly steals property. And then it has to be one of these things. Causes serious physical injury to any person. So if someone gets hurt seriously, it's going to be first degree. If you're armed with a deadly weapon, so you have a gun, first degree. If you use or threaten the immediate use of a dangerous instrument against any person. So you have a knife out and you actually threaten to use it. Robbery in the first degree. You display or threaten the use of what appears to be a deadly weapon or dangerous instrument. So you make this motion under your coat, and you can't tell, but they think that you have a gun there. You display or threaten what appears to be a deadly weapon. So that's going to fall under this as well. Stealing any controlled substance from a pharmacy. So if you go into a pharmacy and you tell them to give you, whatever, because it's a pharmacy, that's first degree. And then it says robbery in the first degree is a Class A felony. And if you back up here, we can look at robbery in the second degree as well. And it says commits offense of robbery in the second degree if you forcibly steal property and in the course thereof cause physical injury. So none of the other things have to be there. So you could have caused physical injury with your hands. You could have knocked somebody to the ground and they hit their head. That would be robbery in the second degree, and that'd be a Class B felony. So there's your differences between first and second degree robbery. So if I were to give you an example, you've got to be able to look at the statutes, look them up, and identify which one it would be. Here are lots of the others. 568 is offenses against the family, bigamy, incest, abandonment of a child, endangering the welfare of a child, trafficking of children. All of those are in here. Let's click on bigamy. That, as you should know, is marrying another person. Person commits the offense of bigamy if he or she purports to marry another or cohabits with one whom he or she entered into a bigamous marriage in another jurisdiction. So either of those two things. So basically and the reason they say purports to marry another is that legally you can't have two marriage contracts at the same time. So like you can't legally be married to two people. So that second marriage isn't actually real. It's fake. So that's why they call it purports to marry, because you're pretending. You're really not married. But if you're going through the process and pretending that you are, and you're trying to act like you are, that is against the law. And then it says, a married person does not commit bigamy if, at the time of the subsequent marriage ceremony, he or she reasonably believes that he or she is legally eligible to remarry. So like, let's say you filed your divorce thing and you've signed the papers and you mailed them off and they got lost in the mail. And you didn't know that and you went ahead and got married, but they never got received. Okay, so it says here you didn't commit bigamy if at the time of your ceremony you reasonably believed you were legally eligible. Okay, so that's kind of how that explains that one. It says the defendant shall have the burden of objecting the issue of reasonable belief. So if that happened, you would have to prove it. That would be your part of your defense. And then it says an unmarried person commits the offense of bigamy if he or she purports to marry another knowing the other person is married. So if you already know the person's married and you marry him anyway that second time, even though you weren't married, you're also committing bigamy. So that unmarried person who's in this fake marriage is also going to be charged with bigamy. Or if you cohabit with one whom you entered into a bigamous marriage in another jurisdiction, so you went and got married in another state and signed it, well, that second state's not valid anyway. And if you live with them, then that's going to be bigamy as well. And it says it's a Class A misdemeanor. So notice this is not a felony. This one falls under misdemeanor. So there's a lot of different things that you have to look into. Abandonment of a child. If you look here on abandonment of a child, get this one to load here. Love when the internet decides to be slow. Abandonment of a child. Person commits the offense of abandonment of a child in the first degree if, as a parent, guardian, or other person legally charged with the care or custody of a child under the age of 4, he or she leaves the child in any place with a purpose wholly to abandon the child under circumstances which are likely to result in serious physical injury or death. So it's first degree abandonment if you leave them somewhere and you deliberately leave them there and it's in a situation that there's a good chance they could be hurt or die. That's first degree Class B felony, unless the kid dies. And then if the kid dies, it's a Class A felony. So, yeah, that's that. So all kinds of different things here. Trafficking is under here. Endangering the welfare of a child. This one I think is there's a lot of things that fall under endangering the welfare of a child. This is something that you have to be really careful about whenever you become the old friend in your friend group, because sometimes you might think that, you're 18, but you're still hanging out with 17-year-olds, or you're legally an adult and they're not. So a lot of these have to deal with under the age of 17. So, you're 19 and your friends are 16. For instance, knowingly acts in a manner that creates a substantial risk to life, body, or health of a child less than 17 years of age. So you're 18, you're a legal adult. You decide to have your friends all go and do some sort of fight or whatever, and you're there and you're encouraging that, then that's endangering the welfare of a child. Knowingly engages in sexual conduct with a person under the age of 17, over whom the person is a parent, guardian, or otherwise charged with care and custody. Knowingly encourages, aids, or causes a child less than 17 of age to engage in any conduct which violates, and then they give you another chapter where you can look up the list of things. presence of a child less than 17 years of age or in the residence where a child less than 17 years of age resides, unlawfully manufactures or attempts to manufacture compounds, produces, prepares, sells amphetamines or meth. So this is the meth lab families. There's a family that's got a meth lab going on and you have kids who are 16 or under there, then they could be charged with endangering the welfare of a child. These all examples are first degree. And then it does say on here, like, what would be a Class B, a Class A, a Class C, and a Class D. So generally speaking, it's a D unless, and then they have 3 exceptions. Like if this thing happens, it's Class C. If this thing happens, it's Class B. Or if there's death, it's Class A. So you've got to be able to interpret these various statutes if I were to give you a case study. Okay, let's look at just a couple more. Here are some public safety offenses. So like voting while intoxicated, the chemical test for alcohol content of blood, and consent is implied. All of those different things are listed in here, so those are good to take a look at. Damaging state property, littering, failure to report a shooting, all of those are in here. Abandoning a motor vehicle, leaving the scene of an accident. Let's take a look at that. Leaving the scene of an accident. A person commits the offense of leaving the scene of an accident when, 1, being the operator of a vehicle involved in an accident, resulting in injury or death or damage to the property of another person, and having knowledge of such accident, he or she leaves the place of the injury, damage, or accident without stopping and giving the following information to the other party or to a law enforcement officer, or if no law enforcement officer is in the vicinity, the nearest law enforcement agency. So it does say you could give the information to the other party. It doesn't mean you have to necessarily have the cops there, but you do have to give your information to the other party. Your name, residence, registration license number, your driver's license number, all of that stuff. And then it says here, all the other things that go along with it, and the offense of leaving the scene of an accident, Class A misdemeanor, Class E felony if there was physical injury to the other person or damage in excess of $1,000 to the property, or if you've previously done this before, then it's a felony instead of a misdemeanor. And then a Class D felony if death occurred. So you've got those examples there. Let's look at the last one here. We'll look at leaving a child unattended in a motor vehicle. So first off, it describes what these things are. Collision is vehicle coming into contact with an object or person. Injuries, physical harm. Motor vehicle, any automobile, truck, trailer. And unattended, meaning not accompanied by an individual 14 years of age or older. So if you're in a car with somebody who's 14 and you're 6, you're not unattended because there's a 14-year-old in there. But if you have like a 10-year-old with a 6-year-old, they'd be considered unattended if it falls under these categories of things that happen down here. A person commits the offense of leaving a child unattended in a motor vehicle in the first degree if such person knowingly leaves a child less than 11 years of age unattended in a motor vehicle, and such child fatally injures another person by causing a motor vehicle collision or by causing the motor vehicle to fatally injure a pedestrian. So look at that carefully. It's the offense of leaving a child unattended in a motor vehicle in the first degree if they're under 11 by themselves and the child hurts someone else or causes a collision. So that means like the kid gets up there and drives the car or knocks the car into neutral and it, whatever. Okay? That's first degree. It says leaving a child unattended in the first degree is a Class C felony. So if that should happen, that's a Class C felony. The second one says a person commits the offense of leaving a child unattended in a motor vehicle in the second degree if such person knowingly leaves a child less than 11 years of age unattended and such child injures another person by causing a motor vehicle collision or by causing the motor vehicle to injure a pedestrian. So the first one was fatally injuring a pedestrian, and the second one is just injuring a pedestrian, and that one's a Class A misdemeanor. So does this say anything about just leaving an 8-year-old sitting in the car with the car running? No, that's actually not, by this definition, leaving a child unattended in a motor vehicle. So what people think is leaving a child unattended in a motor vehicle is not what the law says it is. What the law says it is if when you leave them there, they do something that's going to get them hurt. They drive the car, they do something like that. Now, where you've seen situations that have happened that have been in the news are like someone leaves their kid in the car and it's 120 degrees and the kid dies in there. Well, that's different. And they're obviously going to be charged with something other than leaving a child attended in a motor vehicle if something like that happens. That's a whole different situation. So in the case here is an example, parents charged in death of child left in hot car. Well, in this particular case, the parents were charged with second-degree involuntary manslaughter in the death of their daughter because they left the baby girl in a hot vehicle for 12 hours on a hot day. Other things that they might do rather than the other is abuse or neglect of a child. And that all is a little bit different. And this would be like if the kid, ended up being okay, if the kid didn't die. You could say abuse is the infliction of physical, sexual, or mental injury against a child by any person 18 years of age or older. And it says not by accidental means of a child, hurt in that way. And then they have that on here. The person offensive abuse or neglect of a child, if such a person knowingly causes a child who's less than 18 years of age to suffer physical or mental injury as a result of abuse or neglect, to be placed in a situation in which the child may suffer physical or mental injury as a result of abuse or neglect. The person commits the offense of abuse or neglect of a child if such person recklessly causes a child who's less than 18 years of age to suffer from abusive head trauma. So there's lots of different ones on here that, it could be. Person does not commit the offense of abuse or neglect of a child by virtue of the sole fact that the person delivers or allows the delivery of a child to a provider of emergency services. So what they're saying is, if something happened and you brought the kid to the emergency room, that doesn't mean that you neglected the child. That's not an immediate thing that they can get you for just because of that. Anyway, so there's all kinds of different things in here. So if a child gets harmed, there's lots of different statutes they have to look at. Abuse or neglect might be one. Endangering the welfare of a child might be one. And then as we talked about here, leaving a child unattended in a motor vehicle, that has a very specific one. But that could be one as well. So take some time to look through the statutes and make sure that you understand how to interpret them.